Hello and welcome everyone to the Drishti IAS English YouTube channel. I am Pragya with you here today. So, as you all are aware that the UPSC exam is just round the corner, and to take your preparation to another different height, we have started with two new programs. So, the first program is the Target UPSC Current Affairs Series. Target UPSC Current Affairs Series, which premieres at 1 o'clock in the afternoon, and in this series we are covering all of the current affairs related to various subjects. Then there is Target UPSC MCQs Practice Series, in which we are targeting the UPSC Prelims by way of MCQs. So in the previous episode we were discussing the MCQs related to the subject of history, and in our today's episode we will be covering the MCQs related to the subject of polity. Let us begin. So the very first question is, consider the following statements. So your statement number 1 is, under Article 368 of the Indian Constitution, Parliament has the power to amend the preamble, but the basic features or the basic structure should not be altered. Your statement number 2 is, the 44th Amendment Act of 1978 added the words socialist, secular and integrity to the preamble. So, which of these statements given above is are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. So, the correct answer is going to be option A. Statement 1 only is correct. So, under Article 368 of the Indian Constitution, the power related to the amendment of the Constitution is mentioned. Amendment of the Constitution is mentioned, under which the Indian Parliament has the power to amend the preamble of the Indian Constitution, but the basic structure should not be altered. So, in the 𝐏𝐸𝐴 Bharti case, the basic structure doctrine was evolved, and in this case itself the Honorable Supreme Court has laid down that the Parliament, by exercising their amending power, cannot alter the basic features or the basic structure of our Indian Constitution. So, preamble, whether the preamble is a part of the Constitution or not, was very controversial in nature, and it has been evolved by a series of judgments. So, if you remember the 𝐸𝐵𝐴 Union case, 𝐸𝐵𝐴 Union case, in this case, the Supreme Court has recognized that the significance of the preamble is there, but it was held that it is not the part of our Indian Constitution. Then came the 𝐾𝐸𝐴 Bharti judgment, and in this case, the Supreme Court reversed the judgment of 𝐸𝐵𝐴 Union case and held that preamble is part of the Constitution and it can be amended, but the basic features or the basic structure of our Indian Constitution cannot be altered. And that is why your statement number 1 is correct. In the LIC of India case, which was determined in the year 1995, the Supreme Court has again held that the preamble is an integral part of our Indian Constitution. Why your second statement is not correct? Because throughout the history of Constitution of India, the preamble has been amended just once, and it was by way of the 42nd Amendment Act, okay, and not the 44th Amendment Act. So, the 42nd Amendment Act has added these words, socialist, secular and integrity to the preamble. This amendment was held valid as it enriched the preamble and specifically reflected the philosophy of our Indian Constitution. Let us proceed to our second question. So, the question is, according to Article 3 of the Constitution of India, the Parliament by law, number 1, declare war on any country, number 2, alter the boundaries of any state. Option 3 is increase the area of any state, and option 4 is establish an autonomous council within any state. So, select the correct answer using the code given below. Your option A is 3 only, option B is 1, 2 and 4 only, Option C is 2 and 3 only, and option D is 1, 2 and 3 only. So your correct answer is going to be definitely option C, that is statements 2 and 3 only are correct. Okay, so Article 3 talks about the power of the Indian Parliament to increase or decrease the boundaries of state. To increase or decrease the boundaries of state. Okay, and it can also increase the area of any state. Okay, so according to Article 3 of the Indian Constitution, the Parliament may by law firstly form a new state by separation of territory from any state, or by uniting two or more states or part of states by uniting any territory to a part of any state. Secondly, increase the area of any state, and hence option 3 is correct. Diminish the area of any state and alter the boundaries of any state. Okay. Hence option 2 is also correct. Alter the boundaries of any state. Alter the name of any state, and the Parliament can also declare a war on any country when there is an external aggression under Article 352 of our Indian Constitution. Okay, and this is why this option is not correct. Okay, and Article 3 is not related to the autonomous councils, hence option 4 is also not correct. Which article is related to the autonomous councils, or which schedule is related to the autonomous councils? You will let me know in the comment box below. Moving forward to question 3 of our today's discussion. So the first statement is, the Fifth Amendment Act of 1955 impart precedent to fix time for state legislatures to express views regarding alteration of areas, boundaries and names of state. And your statement number 2 is, Union Territory of Delhi was redesigned as the NCT of Delhi, or the National Capital Territory of Delhi, by the 69th Constitutional Amendment Act of 1991. So, which of these statements given above are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. So, your correct answer is going to be both option 1 and 2 are correct. Both of these statements are correct. So, the Fifth Amendment Act of 1955 impart the precedent to fix time limits for state legislatures to express their views regarding the central legislature. Okay, so hence statement number 1 is correct. Okay, and definitely the NCT of Delhi was redesignated by the 69th Constitutional Amendment Act, which has added Article 239 clause AA and Article 239 clause AB to the Indian Constitution, which talks about the special status that has been granted to the National Capital Territory of Delhi. Moving forward to the fourth question of our today's discussion. Okay, so the question is, which of the following about the Constitution of India is not correct? Always read the question carefully and pay attention to these kind of words which are very negative in nature, because in haphazard manner, if you will not read the question, you will think that which of the following statements are correct when it is written that it is not correct. Okay, so kindly read the question paper very carefully. So your statement 1 is, the size of the constitution is large because it is a single constitution for both of the centers and the states. Your statement number 2 is, there are provisions for a separate constitution of northeast states if approved by the states by special majority. Your option C is, the provisions of the Constitution of India are borrowed from various countries. And your option D is, the basic structure of the Indian Constitution stands on the Government of India Act of 1935. So, which of these statements is not correct? So, your correct answer is going to be option B. There are provisions for a separate constitution for Northeast states if approved by the states by a special majority is not correct. The only state which is now an erstwhile state to have a separate constitution was the state of Jammu and Kashmir. But after the Jammu and Kashmir Reorganization Act of 2019, the Constitution of India applies to the Union Territory of Jammu and Kashmir. So, it was bifurcated into the Union Territory of Jammu and Kashmir and Ladakh. Also, the separate constitution was abolished and now the Constitution of India applies to the Union Territory of Jammu and Kashmir and Ladakh. The Constitution of India is the lengthiest written constitution, which is an elaborate and detailed document with around 470 articles that have been divided into 25 parts and 12 schedules due to various constitutional amendments. Why? Because our constitution is dynamic in nature. It is never static in nature. It has the capacity to change as per the changing times, okay? And there is no provision for a separate constitution as I have mentioned for the Northeast states. Moving forward to our next question, that is question number 5. So, consider the following statements. So, statement number 1 is the voting age was reduced to 18 years from 21 years by the 61st Constitutional Amendment Act. And your statement number 2 is universal adult suffrage is practiced only for the elections to the Lok Sabha. So, which of these statements given above are correct? Your options are option A is 1 only. Okay. Option B is 2 only. Option C is both 1 and 2 and option D is neither 1 nor 2. So, as you have realized that yes, option A only is correct. That is the statement number 1 is correct. Okay. So, the Indian democracy functions on the basis of one person, one vote. One person, one vote. Every citizen of India who is 18 years of age or above is entitled to vote in the elections irrespective of religion, race, caste, sex, descent and place of birth or residence. So, you cannot discriminate any Indian citizen on these grounds. And your statement number is 1 is correct because it was reduced to 18 years from 21 years by the 61st Constitutional Amendment Act. Okay. And this right of voting is known as the universal adult suffrage. Article 325 of the Indian Constitution ensures universal adult suffrage and provides that no person be ineligible for inclusion in or claim to be included in a special electoral roll on grounds of religion, race, caste or sex. Okay. And Article 326 of the Indian Constitution, Article 326 of the Constitution provides that elections to the House of People as well as to the state legislative assemblies, to be on the basis of universal adult suffrage. And if you talk about the elections that are taking place for the urban and local bodies as well after the 73rd and the 74th Amendment Act of our Indian Constitution, they also take place on the basis of universal adult suffrage. Okay. And that is why your statement number 1 is only correct and not your statement number 2. Moving forward to the next question, that is question number 6. Okay, so which one of the following statements best explains the full faith and credit clause of the Constitution? Option A, it provides that all citizens of the country are expected to have faith and follow the Constitution in letter and spirit. Okay. Your option B is it provides that the direction of the union government is to be followed by the state government in full faith and credit. Your option C is it lays down that the full faith and credit is to be given throughout the territory of India to public acts, records and judicial proceedings of the center and every state. And your option D is none of the above. Okay. So your correct answer is going to be option C. The Constitution of India lays down that the full faith and credit is to be given throughout the territory of India to public acts, records and judicial proceedings of the centre and every state. So it has been laid down under Article 261. So the Constitution of India under Article 261 contains the full faith and credit clause, which says full faith and credit shall be given throughout the territory of India to public acts, records and judicial proceedings of the union and of every state. Okay. The aim is to ensure that the acts, records and judicial proceedings of one state may be recognized and implemented in other states without any difficulty. And that is why you see that whenever you have a decree in your favor, okay, whenever you have a favorable judgment in your favor and the High Court, one High Court has given that judgment, so it can be enforced by the other courts if the property or the matter is in the jurisdiction of the other court, okay, and that is why it has given that yes, public acts, records and judicial proceedings can be enforceable from one state to another without any difficulty. Now let us move to question 7 of our today's discussion. So the question is, which amongst the following amendment acts had brought Tamil Nadu Reservation Act of 1994 under the 9th schedule? Okay. So your options are, option A is 29th Amendment Act of 1972. Your option B is the 74th Amendment Act of 1992. Your option C is the 76th Amendment Act of 1994. And your option D is the 78th Amendment Act of 1995. So your correct answer will be the 76th Amendment Act of 1994. And what is the 9th schedule? The laws which are placed in the 9th schedule could not be challenged. Could not be challenged before the courts in India. But in the 𝐈𝐀𝐒 case, the Supreme Court said that or held that yes, even if you are putting the law in the 9th schedule, we can judicially review it if it is prima facie arbitrary in nature, if it is prima facie malified in nature. Okay, so the 76th Amendment Act of 1994 brought the Tamil Nadu Reservation Act of 1994 under the purview of 9th schedule. So reservation is about facilitating access to seats in government jobs, educational institutions and even legislatures to certain sections of the population. Okay, and these sections have faced historical injustice due to their caste identity or backwardness. As a quota-based affirmative action. So reservation, whenever I deal with reservation, I always explain to you that yes, it is a affirmative action of the state. The reservation can also be seen as a positive discrimination. Positive discrimination. And you might be confused that is it allowed under Article 14 of our Indian Constitution? Yes. This positive discrimination is allowed under Article 14 of the Indian Constitution. It does not violate the right to equality because you cannot treat unequals as equals. Okay, you cannot treat unequals as equals. You have to bring them at a level playing field, and that is why reservation is, this positive discrimination is allowed under Article 14 of our Indian Constitution. In India, it is governed by the government policies backed by the Indian Constitution. So, the very first case related to the reservation is the landmark judgment of the Indra Sohani versus Union of India. Okay, Indra Sohani case. Okay, so the Supreme Court, while upholding the 27% quota for the backward classes, struck down the government's notification reserving 10% government jobs for the economically backward classes among the higher castes. The Supreme Court in the same case also upheld the principle that the combined reservation beneficiaries should not exceed the 50%, and this is famously known as the 50% ceiling. Okay, the concept of creamy layer was also evolved in the Indra Sohni case. So, notwithstanding the judgment passed by the Honorable Supreme Court in the Indra Sohni case, okay, many states have passed laws breaching the limit of 50%, such as Maharashtra, Telangana, Tamil Nadu, Haryana, Chhattisgarh, Rajasthan and Madhya Pradesh. But all of the validity is currently sub judice before the Honorable Supreme Court. In many cases, the Supreme Court has said that if the state is able to prove the backwardness, then yes, the 50% ceiling can be breached. Okay, moving forward to our next question, that is the question number 8. Okay, so which one of the following statements about the directive principles of state policy that are mentioned under part 4 of our Indian Constitution is again not correct? So whenever there is a statement based question, kindly read it carefully. I am reiterating it because many of you in hasty manner read it as correct, okay, and hence you lose out on your valuable marks. And mind you, UPSC has a negative marking, so each question is important. Your option is the directive principles constitute certain ideals for social justice. Okay, your option B is the directive principles are adopted from the Irish Constitution. Bag of borrowing. We have borrowed various significant provisions of our Indian Constitution from various countries, okay, but mind you, Indian Constitution is a original document. It is very much suited to the Indian environment. You cannot say it is a borrowed document, okay, because it has certain unique special features, and we have discussed it all in detail in our Polity Primer series. Okay, so the option C is the sanction behind the directive principles is legal, and your option D is it aims to fulfill the objective of socio-economic justice. So definitely your correct answer is going to be option C. It is not correct because the directive principles of state policy are non-justiciable in nature, and it has been mentioned under Article 37 of our Indian Constitution that yes, you cannot go to the Indian courts to enforce your directive principles of state policy. Okay, so the directive principles of state policy are present in part 4 of the Indian Constitution from Articles 36 to Article 51. Article 51. Okay, they are aimed at providing social and economic justice to people and seek to establish a welfare state in India where there will be no concentration of wealth in the hands of a few. They also serve as a guide to the state to formulate laws and policies, and hence they are called the instrument of instruction. Instruments of instruction to the legislature and the executive. However, unlike the fundamental rights, DPSPs are non-justiciable as I mentioned, and it has been provided under Article 37 of our Indian Constitution, and that is why option C is not correct. Now, let us move forward to the next question of our today's discussion. So, the question is, consider the following statements. Your statement number 1 is, both citizens and foreigners enjoy protection against arrest and detention in certain cases under the Indian Constitution. Your statement number 2 is, only citizens enjoy freedom to manage religious affairs under the Indian Constitution. Your statement number 3 is, an overseas citizen of India, OCI card holder, is entitled to the right of equality of opportunity in the matters of public employment. So, which of these statements given above is our correct? Your option A is 1 and 2 only, option B is 1 only, option C is 3 only, and option D is 1, 2 and 3. All of these statements are correct. So, your correct answer is going to be option A, 1 only, that both citizens and foreigners enjoy protection against arrest and detention in certain cases in the Indian Constitution, and this has been mentioned under Article 22 of our Indian Constitution. So, under Article 22 of the Indian Constitution, they enjoy protection against arrest and detention, both citizens and the foreigners. Under Article 26 of the Indian Constitution, both foreigners and citizens enjoy freedom to manage their religious affairs, and that is why your option 2 is not correct. It is not applicable only to the citizens, it is applicable to both citizens and non-citizens. And OCI holders, that is the OCI card holder, is a person registered as OCI card holder under the Citizenship Act of 1955. Citizenship Act of 1955, and is entitled to rights as a union government may specify for them. Okay, and an OCI shall not be entitled to the following rights. So your first right is he or she shall not be entitled to the right of equality of opportunity in the matters of public employment. So they are not entitled for this right. Okay, he or she shall not be eligible for election as the President of India. President of India. And he or she shall not be entitled for registration as a voter. We have still not given the voting rights to the OCI citizens of India. Okay. Now moving forward to the next question of our today's discussion. So the question is, consider the following statements. Your statement number 1 is, a child born in India on and after 3rd December 2004 are considered citizens only if both parents are citizens of India, or one of whose parents is a citizen of India and the other is not an illegal migrant at the time of his birth. Okay. Your statement number 2 is, a person born outside India from 3rd December 2004 onwards shall not be a citizen of India by descent unless his birth is registered at an Indian consulate within 5 years of his birth. Okay, date of birth. Your statement number 3 is, in India, both citizens by birth as well as naturalized citizens, okay, are eligible for the office of president. So, which of these statements given above are correct? Your option A is 1 only, option B is 1 and 3 only, option C is 1 and 2 only, and your option D is 3 only. So, your correct answer is going to be option B, 1 and 3 only are correct statements. Okay. So, acquisition of citizenship by birth. Okay. States that a person born in India on or after 26 January 1950 but before 1st July 1987 is a citizen of India by birth irrespective of the nationality of his parents. Then it states that a person born in India on or after 1st July 1987 is considered as a citizen of India only if either of his parents are citizen of India at the time of his birth. Okay, and those born in India on and after 3rd December 2004 are considered citizens only if both parents are citizens of India and one of whose parents is citizen of India and other is not an illegal migrant at the time of his birth, and that is why your statement number 1 is correct. Okay, citizenship by descent. Okay, citizenship by descent as prescribed by the Citizenship Act of 1955. Citizenship Act of 1955. Okay, is that if a person is born outside India on after 26 January 1950 but before 10th December 1992, 10th December 1992 is a citizen of India by descent. By descent. If his father was a citizen of India at the time of his birth. The person born outside India on or after 10 December 1992 is considered citizen by descent if either of his parents are citizens at the time of his birth, and from 3rd December 2004. Okay. Person born outside India is considered citizen of India by descent if his birth is registered at a Indian consulate within 1 year. It is not 5 years, it is 1 year of his date of birth, and that is why your statement number 2 is incorrect. And in India, both citizens by birth as well as naturalized citizens are eligible for the office of president, and that is why your correct answer is B. Option 1 and 3 only are correct. Moving forward to our next question of our today's discussion. Okay, and this is a practice question. So, which of the following writs is are not issued? Again, pay attention to these negative words. I am reiterating this again and again for you. Okay. Not issued against private individual. Your option 1 is prohibition. Option 2 is certiorari. Option 3 is habeas corpus. So, select the correct answer using the quotes given below. Your option A is 1 and 2 only. Option B is 2 and 3 only. Option C is 3 only, and option D is 1, 2 and 3. And this answer will be given by you to me in the comment box below. I hope this session was insightful for you. If you have any feedback regarding this session, you can drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. And see you in my next episode. Till then, keep practicing, okay, because practice and practice makes a man successful in the exams. It will help you to avoid the negative marking, and it will also help you to realize the scale of your preparation. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.